The Solid Waste Disposal Act was one of the first major environmental statutes passed in 1965. It was a broad attempt to address solid waste problems confronting the nation. First, it was intended to address advancements in technology that resulted in the creation of vastly more amounts and types of wastes than in the past. And second, to address the rapid growth in the nation's metropolitan areas that had caused these areas to experience significant financial, management, and technical problems associated with waste disposal. No longer were the wastes produced biodegradable, and leaving them in the outside dumping areas or less regulated landfills sufficient. Unfortunately, the Solid Waste Disposal Act was unsuccessful in addressing its primary problems, which was the management of hazardous wastes. After a decade, the Solid Waste Disposal Act was deemed insufficient as structure to address waste disposal issues. The Resource Conservation and Recovery Act of 1976, or RCRA, was developed to amend and replace the Solid Waste Disposal Act, becoming law on October 21, 1976. Besides totally revamping the Solid Waste Disposal Act's solid waste program, RCRA also created a national cradle-to-grave hazardous waste management tracking program to deal with the nation's annual production of 3 to 4 billion tons of discarded material. RCRA is one of many environmental laws that were developed by Congress in exercise of its plenary power to guide management of natural resources in the environment by creating minimum environmental standards. Authority is granted to the Environmental Protection Agency to develop detailed regulations for defining and implementing these minimum standards. However, unlike most of the other statutes passed during this era, the Resource Conservation and Recovery Act did not include provisions which provided that tribes would be treated as states within the statutory framework. These other statutes are relevant because while RCRA is the primary statute for solid waste management, there are various other environmental statutes that will overlap enforcement, particularly with relation to water and air pollution, often seen in solid waste management. For example, with leachate from open dumps near water resources, the Clean Water Act may apply. Air quality in the Clean Air Act may apply with the burning of waste. Under these environmental laws, states and tribes are primarily responsible for implementing and enforcing the national standards on a local level. It is in the discretion of tribes and states to set higher standards, but they cannot go below the minimum standards set by these statutes and the associated regulations and guidelines developed by the EPA. Under a majority of environmental laws, tribes can apply for regulatory programmatic authority through the treatment as states provisions of these federal statutes. Statutes that provide treatment as states include Clean Air Act, Clean Water Act, including multiple certifications and permit programs, the Safe Drinking Water Act, including those programs, the Toxic Substance Control Act, and the Federal Insecticide, Fungicide, and Rodenticide Act. Tribes have inherent sovereign power to protect their members' health, safety, and welfare by regulating the environment. So even without the treatment as state status, tribes may exercise regulatory authority within their lands as long as that regulation is consistent with the federal environmental laws. The tribes as state provisions apply to the tribe's legal sovereign status and is an exercise of Congress's plenary power to increase tribes' regulatory authority. There are various reasons why tribes would want a tribes as state status. First, the tribes as state status gives tribes eligibility for financial and technical assistance under the laws as well as programmatic approval. Tribes get the same access to grants and funding and programs that the states do to administer and enforce these environmental laws. Federal environmental statutes with the tribes as state status allows tribes to take their inherent sovereign authority a step further by giving them delegated federal power, increasing their legal sovereign authority to regulate pursuant to these statutes, which provides additional support for tribal jurisdiction over non-Indians. Without this clear definition and delegation of authority, it's a lot harder for tribes to enforce the Clean Water Act, the Clean Air Act, and other environmental statutes, where enforcement may require authority outside of tribal boundaries. While there are various statutes which have the tribes as state status, the primary ones include the Clean Water Act and the Safe Drinking Water Act of 1974. The Clean Air Act also contains a tribes as state provision. The Clean Air Act was passed in 1970, but the treatment as state provision was passed in 1990 as part of an amendment. Under the Clean Water Act, the Safe Drinking Water Act, and the Clean Air Act, EPA initiated a simplification rule to streamline tribal eligibility for program authorization under these acts. The value of this rule is that once a tribe is eligible under these acts, the process for obtaining eligibility for other acts is more streamlined. The agency initially chose to implement provisions of the Clean Water Act and the Safe Drinking Water Acts regarding Indian tribes by establishing a formal pre-qualification process under which tribes can seek eligibility under these statutes for the tribes as state status. This pre-qualification process has in the past been referred to as approval for treatment estates. Under the new simplification rule, tribes do not need to go through a separate pre-qualification process for their program approval. They must only show certain elements along with their program approval application. Tribes need to show that they are federally recognized to receive program approval from EPA. They must show that they have a governing authority to carry out the substantial duties and powers of their program. This could be done by showing a tribal council or a process identified in codes where the tribal environmental program has authority for substantial duties and powers under their program. Likewise, tribes must show that they have adequate jurisdiction to carry out their program. This would include showing statutes over program goals demonstrating subject matter jurisdiction, as well as some sort of adjudicatory jurisdiction for enforcement of the rules. It is also advisable that tribes provide maps and clarifications on the territories that they regulate and plan to regulate under the program. This may or may not include disputed areas of jurisdiction. Once the agency has arrived at a position concerning a boundary dispute, it will not alter that position in the absence of significant new factual or legal information. By contrast, however, a determination that a tribe has inherent jurisdiction to regulate activities in one medium might not conclusively establish its jurisdiction over activities in another medium. The EPA will only provide program authority to a tribe within an area where the tribe has demonstrated jurisdiction. These federal statutes do not delegate authority to states over tribal lands. It does not delegate jurisdiction for states to enforce environmental laws on tribal lands, which means either the federal government would have to enforce these environmental laws or tribes would have to do it. The EPA may enforce environmental laws in some cases on tribal lands in the absence of a tribe's estate's authority or in the absence of the tribe taking responsibility for enforcing these laws. It is more effective if tribes are enforcing these environmental laws on their lands, and the tribe's estate status provides tribes with additional resources to do this.